Hello and welcome to Delhi Law Firm. Today's discussion begins with a major development that has created a strong buzz in the legal community as well as among common citizens. On 6 November 2025, the Supreme Court delivered a very significant judgment that will directly impact the procedure of arrest across India. This judgment is closely connected to every citizen's fundamental rights.
Absolutely. This is a landmark ruling that may become a milestone in the coming years. It answers a very basic but crucial question related to arrests, and its effects will be far-reaching. Today we will discuss this decision in depth. The case is Mihir Rajesh Shah versus State of Maharashtra 2025. In this case, the Supreme Court held that whenever a person is arrested, it is mandatory to provide the written grounds of arrest and also clarified the exact time by which this must be given.
Yes, our entire discussion today is based on this recent judgment and the detailed directions issued by the Supreme Court. We will simplify everything. Why the court said this, what the logic behind it is, and how it will affect ordinary citizens as well as the police. Let's begin step by step.
Let's start with the biggest change. The Supreme Court has now ordered that in all crimes, whether previously under the IPC or now under the Bharatiya Nyaya Sanhita or BNS, if a person is arrested, it is mandatory to provide the written grounds of arrest.
Correct. Earlier, this requirement existed only under some special laws like PMLA or UAPA, where procedural safeguards were stronger. But now, the Supreme Court has made this a universal rule, meaning even in simple theft cases or major economic offences, written grounds of arrest must be provided.
And interestingly, the court did not consider this merely a procedural step. It connected it directly with fundamental rights by invoking Article 22(1) of the Constitution. It said, this is not just a legal formality, it is a constitutional protection. The court also linked it with Article 21, the right to life and personal liberty.
Correct. The court clearly stated that failing to provide written grounds of arrest is not just a procedural lapse, it amounts to a violation of fundamental rights.
Now the question arises, why is it so very important? If a person does not even know why they are being arrested, how will they defend themselves? How will they decide which lawyer to hire, what arguments to make, or on what grounds to seek bail?
Exactly. Providing written grounds of arrest gives the accused and their lawyer a fair opportunity to understand the case and prepare a legal defense. This information is the first step in protecting personal liberty.
Information is the biggest weapon in legal defense. Now let's look at how the court has laid down the procedure. The written grounds must be provided in a language the accused understands, whether Hindi, English, or any other language.
The purpose is to ensure real communication, not just completing a formal step on paper. Now let's come to the most important part, the 2-hour rule.
Yes, the Supreme Court has ruled that the written grounds of arrest must be provided at least 2 hours before the accused is produced before the magistrate for remand.
Meaning, if the police are going to present the accused before the court, they must give the written reasons for arrest 2 hours beforehand so the accused and their lawyer can prepare for the remand hearing.
This prevents remand hearings from becoming one-sided, but a practical question arises, is it always possible to give written grounds immediately after arrest?
The court addressed this. It acknowledged that exceptional situations may exist, for example, when the accused is caught red-handed or when delay may destroy evidence. In such cases, the police may give oral reasons initially.
But the court made it clear this exemption is narrow and temporary. Even if oral reasons are given, written grounds must still be provided at least 2 hours before remand.
Now, what if the police do not comply? If written grounds are not provided or not provided on time, the arrest will be considered illegal and the person may be ordered to be released.
However, the court clarified that if it was genuinely impossible to give written reasons at the time of arrest, the arrest will not become illegal immediately as long as written grounds are provided within a reasonable time and at least 2 hours before remand.
Let's return to the Mihir Rajesh Shah case. This was the well-known Mumbai hit-and-run case. The Bombay High Court acknowledged some procedural lapses but refused to quash the arrest because of the seriousness of the offence.
The accused approached the Supreme Court arguing that he did not receive the written grounds of arrest on time, which violated his fundamental rights. The Supreme Court accepted this argument. It held that written grounds of arrest are mandatory constitutional requirement and failure to comply renders the arrest invalid.
The court therefore made the order of his release permanent.
The court also directed that copies of this judgment be sent to all high courts and all state home secretaries to ensure uniform implementation across India.
This means the rule now applies to every state, every police station, and every investigating agency.
And that is why this judgment is being called a nationwide transformation. It will promote transparency and accountability in the arrest process.
In summary, written grounds of arrest must always be given. They must be in a language the accused understands. They must be given at least 2 hours before the remand hearing.
This decision strengthens citizens' rights and encourages police and investigation agencies to adopt transparent and responsible procedures.
However, the real test will be implementation on the ground, because that is where the system often faces challenges.
Absolutely. And as we wrap up today's detailed discussion, we leave you with a question. Will this judgment change the delicate balance between police procedure and citizen rights? Will it strengthen transparency and human rights, or create new challenges for investigating agencies?
Share your views in the comments below. For legal information and guidance, visit our website www.delhilawfirm.news.
At Delhi Law Firm, we are committed to helping every citizen understand their legal rights.
Thank you. See you in the next video with another important legal issue.